This courtroom hearing turns chaotic almost instantly when a self-proclaimed sovereign citizen, Mr. Dale, steps before the judge and begins challenging the court's authority instead of addressing his actual case. Rather than answering simple procedural questions, he launches into a familiar script, demanding that the judge and court reporter prove their legitimacy by reciting their oaths of office. From the very start, it's clear this is not going to be a normal hearing. Calm and composed, the judge explains that the proceedings are already on the record and that official transcripts can be requested through proper legal channels. But Mr. Deo refuses to move forward, repeatedly interrupting and insisting that his demands be met. He clings to pseudo-legal ideas pulled straight from sovereign citizen playbooks, confidently asserting claims that have been rejected by courts countless times before. As the hearing continues, the tension builds. The judge firmly but patiently shuts down each attempt to derail the process, refusing to engage with arguments that have no basis in law. When the conversation shifts to Mr. Deo's request for a jury trial, things become even more confusing. Despite legal explanations from the court and attorneys, he insists his interpretation of constitutional rights overrides established procedure. In a striking moment, Mr. Deo openly admits that he does not understand the legal language being used. Yet still insists on representing himself. The contradiction is impossible to ignore. Even so, the judge grants him an extension to continue researching, demonstrating remarkable restraint and professionalism. By the end of the hearing, one thing is clear: sovereign citizen tactics don't intimidate the court, don't delay justice, and don't work. What they do reveal is the sharp contrast between courtroom reality and conspiracy-driven legal myths. And the patience required of judges who deal with them every day.
Okay, we are back on the record in 2023 TR 2777, State of Kansas versus Anthony Edward DeBoos, with Jared Regier for the state, Mr. DeBoos in person, and with standby counsel Darren Patterson. Standby because my prior contacts with Mr. DeBoos led me to believe that he, even though he wants to represent himself, there's much about the legal system that he doesn't know or understand and would need the benefit, or would certainly benefit, period, from Mr. Patterson's representation. So, Mr. DeBoos, at this time, you want to talk to Mr. Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations?
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
This is a court of record because this is being recorded, subject to transcription at any time.
Okay. I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay. And Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the State of Kansas Corporation.
I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial. Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think, Mr. DeBoos, that you have filed any kind of demand or request or notice for jury trial. Have you?
I thought that was entered into the last court session.
Well, I don't think you filed any motion. You told me apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of any kind. Mr. Patterson, do you believe it's acceptable for him to just say he wants a jury trial?
Your Honor, pursuant to case law, because there are at least up to 1 year in the county jail possible, if it's ever consecutive, then case law would state that he has a right to a jury trial.
Agreed, but does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issuable trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
Mr. Patterson, in spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, and I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay. So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or I mean consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what.
Do you have your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not what I keep handy, but giving a short recess, I can find that.
Well, now, before you go to that, now, Mr. DeBoos, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people granted to us in restriction of government entities for the people itself, I comprehend that I have my right to jury trial, which I thank Mr. Patterson in his brief support towards this and towards me. towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself, Phyllis K. Webster.
All right, well, Mr. DeBoos, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here for this purpose. So here's the thing, Mr. DeBoos. No, let me talk now, Mr. DeBoos. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you? And do you not want to have his legal assistance to let him represent you?
I do not wish to be represented by an attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barriquet was an unlawful arrest for KSA 22-2401.
We're not going down that path right now, sir. Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBoos?
May I ask that there be an extension so that way I may fully research the procedures of the administrative criminal law which we're trying to try.
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pre-trial will be September 30th. 2024. Do you have any objections to that?
No objections.
And Mr. Patterson, do you have any legal authority that suggests that I reaffirm my oath for him? Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right. Well, same here. I do have my oath in front of me. Keep it handy, but I don't see the need to repeat that. It was good enough for the Supreme Court of Kansas.
The courtroom opens, and almost immediately, tension fills the room. Mr. Dio, a self-proclaimed sovereign citizen, steps forward not simply to answer the charges against him, but to challenge the very authority of the court itself. From the moment he speaks, it's clear that this hearing is going to be unlike any typical legal proceeding. He begins by demanding that the judge recite her oath of office, insisting that nothing in this courtroom can proceed without proof that the judge and court officials are properly authorized. When the court reporter is called upon, he repeats the same demands, questioning whether the record is truly official. The judge responds calmly, explaining that the proceedings are already recorded and that official transcripts can be obtained by following standard procedures, yet Mr. Dio remains undeterred. He pulls out references from a so-called sovereign citizen handbook, confident that memorized phrases and pseudo-legal arguments will somehow override centuries of legal precedent. Throughout the hearing, the audience can see the contradiction in his approach. He claims authority over the court while simultaneously revealing his lack of understanding of the law. The judge, however, remains composed, demonstrating the professionalism and control that the law demands. Every attempt Mr. Dio makes to derail the proceedings is met with patience and a firm refusal to engage with baseless arguments. This is the stark reality of sovereign citizen tactics. They may appear intimidating, but in a courtroom guided by law and procedure, they have no power. As the hearing progresses, Mr. Dio shifts focus to his desire for a jury trial. He insists that statutory procedures do not apply to him and that he is constitutionally entitled to a jury, referencing his interpretation of the law. The judge and attorneys explain the proper legal process, including the need to file a written demand for a jury trial. Mr. Dio resists, arguing that precedent supports his interpretation and that he does not need to follow statutory requirements. His standby counsel attempts to clarify that while constitutional rights exist, they must still be exercised according to procedure. Yet, Mr. Dio's insistence on controlling the narrative overshadows any legal advice offered to him, and the hearing becomes a continuous back and forth of procedural explanations and repeated interruptions. At one point, he openly admits that he does not comprehend the legal language being used, yet he refuses representation and continues to assert his own understanding. This contradiction is both fascinating and frustrating. A man confident in his self-taught knowledge of law, yet simultaneously admitting ignorance of the very language and procedures he claims to master. His arguments, while delivered with conviction, lack substance and are repeatedly neutralized by the judge's composed responses. This illustrates a key point about sovereign citizen tactics. No matter how confident or aggressive the approach, they are ineffective when confronted with legal expertise and authority. The judge continues to navigate the hearing with remarkable patience. She refuses to recite her oath again, stating that it was already taken upon her appointment and election. She maintains control, allowing the proceedings to move forward while respecting the defendant's right to speak. Even as Mr. Dio continues to challenge the process, the judge ensures that every necessary legal step is observed, demonstrating how procedure can maintain order even in the face of continuous disruption. The audience watching this could easily see the contrast between chaos and control, between pseudo-legal posturing and the real authority of the court. Throughout the hearing, Mr. Dio's strategy remains consistent: insist on pseudo-legal rituals, demand proof of authority, and assert interpretations of constitutional rights that conflict with established procedure. Yet every attempt is effectively countered by the judge. Even when legal terms and processes are explained multiple times, he struggles to comprehend or accept the explanations, further highlighting the gap between his understanding and the requirements of actual law. This hearing becomes a case study in how sovereign citizen ideology interacts with reality. Theatrics and memorized scripts may create drama, but they cannot influence the outcome when law and procedure are firmly applied. By mid-hearing, Mr. Dio requests more time to study administrative criminal law. Despite the obvious delays caused by his tactics, the judge grants him an extension, scheduling the next hearing to allow him additional preparation. This decision reflects not only legal fairness but also the patience required of judges in these situations. Allowing time for research acknowledges a defendant's right to preparation while still maintaining the authority and integrity of the court. Even as Mr. Dio continues to insist on his version of the law, the courtroom moves forward under the steady hand of the judge, who refuses to be swayed by theatrics or pseudo-legal rhetoric. What becomes clear as the hearing unfolds is the futility of sovereign citizen strategies. Mr. Dio's insistence on personal interpretation and pseudo-legal demands creates conflict and confusion, but it accomplishes nothing in terms of advancing his case. Every interruption, every demand, and every claim is countered by reason, procedure, and authority. The judge exemplifies how knowledge, patience, and adherence to law can neutralize even the most persistent attempts to manipulate the courtroom. For viewer, it is both frustrating and mesmerizing. A clash between ideology and legal reality, a contest of confidence versus expertise. Even as the hearing draws to its continuation, Mr. Dio's choices remain baffling. He openly admits that he does not know the law, yet refuses representation and insists on self-representation. The judge, unfazed by these admissions, demonstrates exactly why professional legal training and courtroom experience are irreplaceable. The proceedings serve as a stark lesson in the limits of pseudo-legal knowledge. No amount of memorized scripts or handbook references can substitute for real understanding of law and procedure. While Mr. Dio may feel empowered by his tactics, the reality is that they are consistently ineffective against a courtroom that follows established rules. As the next hearing date is set, the tension in the room begins to ease. The judge's control ensures that order is maintained despite continuous challenges, and the procedural steps taken protect both the defendant's rights and the integrity of the court. Mr. Dio's insistence on pursuing his own interpretation of law serves as a cautionary tale, showing how overconfidence and misinformation can lead to repeated failure in legal settings. The hearing is a clear demonstration of the power imbalance between a trained judge and an untrained, pseudo-legal-minded defendant. By the end of the session, the audience is left with an unmistakable message. Sovereign citizen arguments, while dramatic and confrontational, are ineffective in a courtroom guided by law and procedure. Mr. Dio's performance, from demanding oaths to asserting his own understanding of constitutional rights, is a study in futility. The judge, through patience, knowledge, and adherence to the law, maintains authority and control throughout, illustrating the difference between theoretical legal beliefs and the realities of judicial procedure. The hearing is both a cautionary tale and a fascinating example of how courtroom authority prevails over ideology, script, and theatrics.